Press.
Second.
Good morning. Good morning, ladies and gentlemen. Everyone, thank you. Okay. Good morning, ladies and gentlemen. We're ready to get rolling. Our first speaker has an appointment at 11 o'clock, so we want to get him rolling quickly. But thank y'all all for being here today on this hugely important topic. And we're going to substance over form. We want to get right into the heart of the issue and get as much data moving and information back and forth as quickly as possible. So without further ado, I'd love to have each one of our committee members introduce themselves, and we're going to be joined in just a little while by Representative Vance Smith as well. He's at a ribbon cutting, and he's on his way in a little while. So why don't we, Mr. Vice Chairman, why don't you, yes, please, will you lead us?
Thank you, Mr. Chairman. My name is Teddy Reese, State Representative, House District 140 here in Columbus, Georgia. I'm also the Vice Chairman behind this great leader here of this committee, and I want to thank you guys for joining us here in Columbus as we host our second meeting for assessing the affordability and the accessibility of the legitimation process. And if you will, just please bow your heads and join us in a word of prayer. Dear Heavenly Father, we come to you right now, Lord, thanking you first for waking us up this morning. We also come to you, God, thanking you for safe travels to this destination as we convene to try to do the work of the people. Lord, we ask that you be with all of us and be with our hearts, our souls, and our minds as we think about and reflect on the challenges that we have right here in the state of Georgia and ways in which we can improve our great state right now this morning, Lord. Lord, we just want to thank you for all the blessings that we have received. Thank you for protecting us when we didn't even know we were in danger. And Lord, we want to thank you in advance for our safe travels back to our home destinations when we have done the work of the people and continue to do the work of the people as we continue throughout this study committee as well as into the next legislative session. Lord, we thank you for the leadership of this committee. We thank you for the leadership of our state. We thank you for the leadership of our individuals in our communities, those that don't get recognition, those that don't get the shine, Lord, but those that are out there every day making the difference, Lord, so that somebody can have a better life. In this and so many things in your name we pray. Amen.
Thank you, Mr. Vice Chairman. Will you do us the honor by leading us off and introducing yourself for the folks, probably the handful of folks in here that don't know who you are? You're kind of a celebrity over here.
Absolutely. I'm not the celebrity. The celebrity just walked in. My wife just walked in, Dr. Chastity Reese. Say hey, baby. Wave at everybody. I asked her to join me today. You know, my wife is a doctor. She's normally at work, but she's also embarking upon her last year in the Physician Executive MBA program at Auburn. So she'll be leaving today for their 1 week cohort on campus to kick off this semester. So safe travel, sweetheart, when you leave here, and I'm very proud of you. But my name is Teddy Reese. I'm the state representative here in Columbus, Georgia, House District 140. We have several representatives that cover this particular area. As a matter of fact, one is on this committee, Vance Smith. He will be with us shortly. He's at a groundbreaking today at Columbus Tech. I was supposed to be at the same groundbreaking, but I thought about the fact that since I'm the vice chairman of this committee, I might need to be here on time. So Vance is covering that for both of us, and he'll be back here shortly. But this is a very important topic, and not just for this local area here, but for the entire state of Georgia. When we think about rights, when we think about birth rights, when we think about parental rights, certainly just basic rights, the first thought that comes to mind is the Constitution and what the Constitution gives you and what it provides you. And so when it comes down to a child and the important responsibility of raising that child, like if you could see the laundry list of items my wife have left for me to do while she's gone for our 8-year-old, getting her ready for school in the morning and everything, but it's a shared responsibility. And we have more people in this state that want to engage in that shared responsibility, and it's our responsibility to assess it, to make sure that even the father has just as many rights as the mother when it's necessary and when it's proper. And so I'm glad to be here today. I'm glad to serve on this committee under the leadership of our amazing chairman. I have just been thoroughly impressed, Chairman Barrett, with your passion on this subject and your willingness to learn about this subject, even though a lot of it deals deeply within law and policy and emotions and change. But, you know, we're called upon to handle and tackle the tough issues, and we're capable of doing it. And I'm looking forward to us having some great resolutions and some great proposals when this study is done to benefit the people of the state of Georgia, particularly fathers.
Thank you, Mr. Vice Chairman. Representative Hefner.
Thank you. Can you hear me? Thank you very much. It's an honor to be here. I am State Representative Lynn Hefner, and I am joined by the esteemed first gentleman of Augusta, Georgia, my husband, Mr. James Hefner. And we represent Augusta's finest, the Garden City of Augusta, Georgia, House District 130. It is a pleasure to be here to serve you and to participate. We understand that my colleagues and I understand that this is very, very important work. My husband and I both, coming from a blended family situation, knowing that there could be a significant amount of challenges that our community members are facing and overall impacting the community. So it is an honor to be joined here with my esteemed colleagues, the chairman and the vice chairman. And I look forward to participating and hearing from all of you and putting together a piece of work that represents what we can do to better serve the residents and the children and families of Georgia. Thank you.
Thank you, Representative. Representative Clifton.
Yes, sir. Thank you, Mr. Chairman. Thank you for everyone for being here. My name is Rob Clifton, District 131, Columbia County. Share a borderline with Representative Hefner over there, and very excited to be here. Fortunately, was not able to be here in person for the last meeting, but in spirit and virtually, and did a little refresher on my nice long drive this morning. So, a lot of topics, a lot of information covered. I think it's apparent there's no simple fix, but there are solutions or there are ideas and stuff we can put in place, and hopefully through the continuance of this meeting and the next one, we'll continue to hear more and can provide some good policy for the state of Georgia. Thank you.
Thank you, Representative. And to both of you for driving all the way from Augusta, thank you for that. And Vice Chairman, thank you in advance for your drive over to Augusta next month. And finally, Brock Perry, would you introduce yourself?
Good morning, everyone. My name is Brock Perry. I'm the attorney analyst with the Georgia House Budget and Research Office assigned to this study committee. I am staff, so I am better seen and not heard. I'll let these people do the talking, but thank you all for being here.
Brock is humble and very smart, and without Brock, we would be a lot less effective than we're going to be. Without further ado, I'd like to introduce our first speaker, Judge Gil McBride, the Chief Judge of the Chattahoochee Judicial Circuit. And Judge, please introduce yourself, and the floor is yours, sir.
All right. Thank you very much, Mr. Chairman. I'd like to thank Representative Reese for inviting me. He is a good friend, fellow public servant here in the Columbus area. My name is Gil McBride. I served 10 years as Chief Judge of this circuit, and in 2022, at the end of 2022, I stepped back to just being judge. So I am happy in that role. It's a daily privilege to serve. I will say that this is a very important subject. Yesterday, I was talking to an intern who has been working with me the last couple of summers. He is a law student over at Mercer. And he and I were talking about today's meeting, and he reminded me that he put together numbers for me last summer that showed that Muscogee County, where we are now, when he looked at the numbers, had a 52% out-of-wedlock birth rate. And within some communities within Muscogee County, it is as high as 79%. But the 52% is an average, and it's a high one. And as is true of most averages, or all averages mathematically, it means some numbers are going to be higher, some are going to be lower, depending on the community. But the takeaway for me is that it is a situation that affects the entire community, irrespective of education level or zip code. So how I became involved in the legitimation efforts of our circuit is something I would like to cover. But before I do that, I do think it would be worthwhile to just cover some of the basics of what legitimation is and why it is important to even talk about it. I will say that for 18 years after I graduated from law school, I practiced law. I did a lot of adoption work in this circuit. I did a fair number of legitimations, but I did a lot of work that involved dealing with the rights of fathers. You cannot finalize an adoption without addressing the legal rights of fathers. And so I was sort of in and out of that issue from all directions and kind of saw it from every point of view. And for the last 16 and a half years, I've seen it from the point of view as a judge. Which gives me, I think, as much perspective on legitimation, at least locally, as most of us are going to have. It's a subject that, for some reason, a lot are reluctant to talk about. And so I applaud this committee for making it front and center. It's very hard to deal with situations and solutions and without at least acknowledging that there are problems. So I preface my remarks by thanking you for what you're doing. I will also preface them by saying that, as is true of most things about coming into this world, your status at birth, whether you are born in wedlock or out of wedlock, is not your destiny. And I think we all know that. But we also know, especially if you're on this committee, that there are certain life outcomes and certain social pathologies that go along with a high out-of-wedlock birth rate. Those facts are out there for any and all to see, such as my law clerk was able to discover in a quick Google search last summer. So I applaud you for addressing the situation, and I applaud you for addressing it honestly and completely, because we're all in a situation where, at least Mr. Reese and I, where we take oaths to tell the truth, but the whole truth. And so I hope that through your endeavors and your researches, you get to the whole truth on this situation. Legitimation goes back for centuries. It's not a new concept. The idea there is that children have been, for a long time, born out of wedlock. And so it's very easy in a birth situation to know who the mother is. So the presumption arose early on in the development of the law that the mother would have legal rights to the child in a situation where a child was born out of wedlock. Sometimes it's not so easy to determine who the father is, and that's just, we're all adults here, and that's just the lay of the land that we are dealing with. So the law created a remedy for biological fathers to attain rights to their children and to share equally in the upbringing of their children, both in the joys of that as well as in the responsibilities of it. And that process is called legitimation. It is a process that is only available to fathers because, again, the mothers have that presumption in their favor. And when I came on the bench, I was elected in 2008, and our then chief judge, Judge John Allen, who recently passed away, he knew that I had a background in this situation, and in these types of situations, I should say. And he called me aside after I was sworn in, and he pointed out to me that he noticed certain commonalities in the young men who were coming before him in his courtroom, especially in criminal cases, and the absence of fathers in the homes that many of those young men came from. And so he asked me to look at this situation in our community and work with a volunteer who he had lined up as well, several volunteers actually, to see if we could make the process a little bit cheaper and a little bit more streamlined once these young men come to court. And so out of that effort came the Legitimation Station. And I've handed you each brochures about the Legitimation Station. We also have brochures that are developed for mothers because, as you can imagine, mothers may take a very different view of legitimation from fathers. But I brought you the father side of the legitimation brochure just because I understood that was really the more narrow focus of this committee. I do have extras for audience members too. Judge Allen, he tasked me with this responsibility, and we were able to organize the Legitimation Station as a way to meet fathers where they were, to hand out brochures where dads were likely to need them. We went to Donuts with Dads at local schools. We went to hospital maternity wards. We went to the front offices of schools, anywhere where a dad was likely to show up and be told that he had no rights to his child. And rather than tell him, we can't help you, see a lawyer, at least the people in those frontline positions could give dad some information, hopefully in a kind way, and say there is a resource to help you. And that's where we wanted to get with the Legitimation Station. And so how it works, just in a nutshell, is we have a team of volunteers who meet the first, second, and third Fridays of each month. And they meet at our Office of Dispute Resolution, which we have just because the facility was already available. And initially, the program was all run by volunteers. And we gradually outgrew the ability to operate it by volunteers. So we were able to get a grant, and interestingly enough, it's a crime prevention grant, to fund a coordinator to recruit volunteers, to schedule them, to make sure that we have equipment and computers that are up and running, and that we're able to guarantee fathers a relatively smooth process once they decide to legitimate. So the grant comes from the City of Columbus, and City Council has recognized the value of the program, and I hope that they continue to do so. It has gained pretty wide community support. It's not intended to solve all of life's problems. It's a legitimation focused program. It's supported by a website. We staff it, as I say, with volunteers, so no legal advice is given at the Legitimation Station. It's simply helping dads, educating them on the need to legitimate, what legitimation involves, and helping them with the paperwork. Now, some dads cannot afford the next step, which is to file the paperwork and to file it with the Clerk of Superior Court in one of our 6 counties. And so for those situations, we do have measures in place in all 6 counties for filing fees, which vary from county to county, to be waived depending upon a showing of indigency. And we do see those affidavits and those applications quite often. So I think the process here, there's always room for improvement, but I do think it's a very smoothly operating process. And through legitimation, I think it's very important to just cover what the benefits are to the father. As noted earlier, he has no rights to a child unless he pursues legitimation in some way. We were seeing a situation, Judge Allen had seen it apparently once too often when he finally decided we needed this program, where young men would raise their children. Perhaps mom had gone into the military, perhaps she'd gone to prison, perhaps she'd just disappeared. But they would raise the child until they were 4 or 5, and then one day they go to school, and the child is not there, and the mother has shown up. And so the initial emphasis was to reduce the frequency of that type of situation. So we started on the front end, as I say, with educating fathers on the need to legitimate, because a man in that situation, he would think, what do you mean I have to go to court? I mean, this is my child, there's no doubt about it. But that's not how the law views it for the reasons that I have stated. So we have come up with this process, and I like to think that it's paying dividends. It's been around now for about 14 years, and fathers, when they legitimate, can attain shared legal custody. In some cases, they can attain primary physical custody. They have the right to receive information about their child, to make decisions concerning the child, to seek emergency care for the child, and to participate in all respects as an equal partner in the upbringing of that child. We also deal with the child's last name. That's part of what the legitimation statute empowers us to do as judges. And then we also set child support. And some say, well, young men won't do this because they'll have to pay child support. And speaking simply anecdotally, that has not been my experience. Plenty of young men who come before me, they understand that's part of the deal going into it. And frankly, they expect that. So it has not, at least as I've seen it, been a deterrent to how the program operates. The child support, the child, and the rights are all sort of a package arrangement, and they all go together, and I think most dads recognize that when they come into the program. At this time, I'll be happy to take questions from the committee.
Can you talk about the scope of, in the 6 counties in your judicial circuit, how many legitimations are there in a typical year, give or take? I mean,
I think that in probably, and we're just now compiling the numbers for 2024, but I would say under 100, but more than 75 in a typical year.
Thank you.
Most of them in Columbus.
Okay. Thank you, Judge McBride, and thank you for your leadership on this. And I will say, a little envious that I didn't get an opportunity to really experience that type of relationship with Judge Allen, who was a very giant figure here in the legal community in Columbus, and certainly on our Superior Court bench. But he was always one who kept his pulse and his hand on community needs and what's going on at the granular level in the community. He never removed himself from society, and it was great to hear that it was his conversation and influence that led you down this path, which I think is so awesome. I do have a couple questions for you. One, you mentioned in your testimony that once fathers go through this program, of course, there's the process of moving forward, which sometimes there's a financial hurdle there. Do you have any concept of what percentage of your fathers can't move forward because they can't afford the process after they finish this training?
Well, the process itself, completing the paperwork, is free to the father, because the first part of it is all done by volunteers and a coordinator who's paid with that grant that I mentioned. But the next step is to take it down the street and file it with the clerk. And so sometimes the filing fee is an impediment, it's an obstacle. And so Georgia does allow paupers affidavits. If a father completes one of those and meets the eligibility and the judge approves it, then the filing fee is waived too. So at that point, it's up to the father to complete filing the paperwork and getting the hearing scheduled. We use some of our ARPA money, which we much appreciate, by the way, to hire a senior judge who handles special dockets of people who are attempting self-representation, including fathers in legitimation cases. And so, you know, I would always urge them to hire a lawyer if they can, but it is designed to be handled and to be as friendly as you can make a courtroom toward pro se people, that is self-represented individuals.
And of course, you are articulating around the process that we have here in Columbus and
Right.
in this in the Chattahoochee Judicial Circuit, which is the 6th county circuit that you spoke of, which is not necessarily available to everyone around the state.
That's correct.
And so I think what I will certainly want my colleagues up here to take from this is look at the extent in which Muscogee County has gone to help fathers in this process, because it is rather difficult for individuals that don't have this kind of help, that don't have the legitimation station, that don't have judges that are making sure there's a senior judge to help pro se litigants. Most fathers probably would feel more comfortable if they had representation, and then we know that's an additional cost as well. Judge, I really appreciate everything that you do in helping fathers in this area, and with this effort. It has been a great effort here in Columbus. You've partnered with entities like the NAACP and other groups in this work that you've done with the Legitimation Station. And I have a close friend of mine who is going through this process right now, where he actually completed it, the legitimation training, and it took him a couple months to amass the funds that he needed to move forward with representation, because he was honestly afraid to go in without representation. There's real fear in some people's hearts in this community that our state is just not friendly to fathers. And they are so afraid, Judge McBride. And I think you have experienced that. I think you know that to be some of the public perception. And what you have done here and the work you have aided in with so many other great partners in doing this is just a testament to when our judicial system is at ground level with the challenges that we have in our community, and making things work for everybody. The court system should work for everybody and not just a few that can afford it. And so, thank you. I
Thank you, Mr. Vice Chairman. We're going to suspend with the formality. I'm not going to recognize y'all to ask questions. Time is of the essence, so I want you just to jump in, representatives, and if you have a question, ask. This is the time to when we've got experts, let's just go and get.
Thank you, Mr. Chairman. Thank you, sir, so much for your presentation and your joining us this morning. I have two questions. One with, if you could speak to the specificity of the types of grant fundings that you had mentioned and whatever partnership that was, because you said, I think it came from a little bit different branch that would look like familial to this type of situation. That's the first question. But the second question is, what demography has your work impacted military personnel? How many of those individuals coming from that 50%, or as it relates just to what the work that you do in this area, how much of that has been military?
Addressing the second question first, if I may. I don't have that information, but I could get it for you. And I could send it to Representative Reese, if that's agreeable. And but I would say right now, and it's not a very specific or legally precise term, but a fair amount would be military, just because we share this long history and a long county line with Fort Benning. And the military counts on our courts to do a lot of things that the military justice system just is not designed to handle. So, but I can get you that. As for the grant sources, there's the crime prevention grant, which is from the city of Columbus, which is funded, I believe, with a sales tax. And then there is also the American Recovery Grant that Governor Kemp made available to our circuit and Georgia's other 50 circuits. We were able to qualify initially for about a $2 million grant. The express purpose of the grant was to clear the backlog of violent felonies that had built up during the pandemic. But the way we approached it was, you really need a Superior Court judge to try a violent felony. As a matter of fact, you have to have one. The Constitution says so. We have exclusive jurisdiction over that. So our approach was to try to use that money to clear the decks, if you will, in our courts so that we could focus on the violent felonies. And out of that came the idea that we could hire a senior judge to operate a special division of our court that handles the legitimation cases and that handles the other pro se types of cases. So that may be more than you want to know, but it's two basic sources of funding. It's the crime prevention grant and ARPA, which is getting ready to run out. So just putting that out there in case y'all are interested in knowing about that.
Your Honor.
Yes, sir.
Your Honor, out of the 49 judicial circuits, you recently were at a convention of the Superior Court judges, I think,
Yes, sir.
A couple of weeks ago. Of the 49 judicial circuits, who else is following your lead around the state?
You know, we have not really kept track of that. I get the feeling that most circuits, just based on the conversations that I hear, are probably not doing it quite this way. But this is one of the older programs in the state, maybe the oldest, as far as I know. It's about 15 years old. And we're happy to share what we've learned and maybe learn from others as well if they're doing this. And I see a fair cross-section of our state there sitting on the committee. So I would be glad to follow up with any of you and speak to any judges or local officials you put me in touch with.
Great. I've spoken a lot with our fellow representatives, and one thing you can observe fairly quickly, we're all sort of newer at the Capitol. One thing you can observe fairly quickly with all the bills that are introduced, there can sometimes be unintended consequences, and we're very keen to make real meaningful progress without doing things in a less thoughtful way where we have unintended consequences that create more problems than they solve. How close are we to having the right balance currently with our legislation around legitimation? Are we close? Is the process elegant? Is it awkward? And how do we look relative to other states? It's not fair to ask you such a huge question when you've got 12 minutes left before you have to go to court.
Well, you know, the only law that we follow in Georgia is Georgia's law. So I'm really not familiar with how other states do it. I will say generally that Georgia's a common law state. It was founded on the English legal system. So a lot of these presumptions that I was discussing earlier arose from our British heritage, the British heritage of our legal system. As for how other states approach it, I think some approach it more as an administrative matter. Georgia has retained the best interests as the centerpiece of most matters involving the raising and the upbringing of children, and I think that's a better standard. I think something as important as legitimating a child and determining who's going to be raising the child and the role they're going to play should have a little bit more judicial input, certainly more evidence, certainly more weighing of evidence by someone who's familiar with the law in that area, so that the best interests of the child can be obtained. This is much different from applying for a driver's license or just a matter of administrative convenience for the state and a citizen. It's a life that's at stake. So I value the role that the courts still play in this here in Georgia. I think it's too important not to be part of the legal process and the legal system.
Do you think there are obvious, based on your personal experience with what y'all have done with the Legitimation Station, do you feel like there are glaring or there are obvious ways to become more efficient as a state?
I think that if other circuits were to go with some version of what we've done here in this circuit, that funding would be a question. There's a limit to how much you can grow these programs just with volunteers, unless you have some really extraordinary volunteers. And I think we've all heard that hope is not a strategy. You know, sometimes you have to pay people to do things. And so funding coordinators for these types of programs, making sure that they have space to operate in, funding senior judges to continue to put these cases aside and treat them with the care and consideration that's needed so that they're not on a regular docket with a number of other cases. I think those are all ways where the legislature has a role to play.
Judge, thank you for introducing, you had a follow-up? Thank you for introducing the legal standard into the conversation today. We talked about it at our last study committee meeting in Atlanta, the best interest of the child, and how that is the standard that we observe by. When you look at the legitimation process and the legal aspect of it, it seems as if, though, the challenge is only with the fathers because the mothers are automatically given that right, and the mother having access to the child may not be the best interest of the child. And so, therefore, that child is left in that situation with a father that may want to assert some type of right to bring that child into a safe environment. And this may be a one-ended hypothetical, but we heard direct testimony last committee meeting in Atlanta where this scenario I'm talking about would apply. Speak to, if you will, the thoughts and feelings of some people that have spoken to me about this topic of it appears that Georgia instantly grants with the mother every right and the father no rights at all. And we know that to be the current status unless you go through the process. But is that truly the best interest of the child?
Well, you know, that's really more of a question for the legislature than, I mean, we follow the law as y'all give it to us. But I mentioned why that presumption has arisen, and it's because often mom's the only one in the room. And we can't create people who aren't there or just whip them up out of thin air. So also, the mothers do have some constitutional rights. And they should have some input into the role that the father is going to play, much as they would if it were a marriage and we were talking about a divorce. They certainly shouldn't be held to a different standard or given a lesser standard or a higher standard to meet. So the mother has some constitutional rights as well when it comes to raising the child that she may share with someone else. So that's why it is a legal process where the court weighs the best interests. And I will tell you that there are quite a few situations where the father walks out of the courtroom with custody of the child. Because I agree with you, the mother is not uniformly the one who it would be in the child's best interest to place the child. But she does have the right to her day in court, notice, an opportunity to be heard on that very important issue.
But the way the system is currently set up, right now as it is, that mother goes directly into the rights if they're not married, and the father has to fight for the rights. Even if he's at the hospital, at the birth, both parents are consenting that this is the father. They've had a long-term relationship, they're just not married. That next week, that mother could take that child and that man would have absolutely no rights. Or 6 years from then, after they've lived together and built a family and raised that child, that mother could walk off with that child and that father would have no right. Now, I know there are some provisions in the law, like if they get married, I think it's a little easier for the...
Yeah, that's one way to legitimize is to marry her.
That's part of the process. But there's some people that feel that if you have two consenting adults at the time of the birth of the child that are both there and both willing and agree to sign a birth certificate, and there's some type of biological aspect of confirming that that father is the child, that the legitimate rights should extend. There are some people that feel that way. What would be your response to that?
My response would be that really it would be twofold. There could be some way to administratively handle it at the hospital, and I think we have experimented with that in the past in this state. But also, there's no reason at all the day they bring that baby home that they couldn't stop off at the legitimation station and complete the paperwork there. It would be whether you do it at the hospital or do you do it 2 miles down the road at the legitimation station. But I think that ultimately, I have a very difficult time and way of conceiving how it would ever be in a child's best interest not to have it finalized legally. I don't see how the child's rights could be protected because you're dealing with inheritance, you're dealing with Social Security, you're dealing with benefits, you're dealing with the child's right to be supported. And I think that it needs the imprimatur of law in some way to protect the child. But I do think that in that situation, they should probably have some way to do it at the hospital, but if they choose not to do that, then they could go a couple of miles down the road to the courthouse and take care of it.
But to your point, it just needs to be wrapped up somehow within the legal aspect to protect that child in the end.
Absolutely.
So even if it starts something at the hospital, and these are some hypotheticals that have just getting your aspect from a judge's perspective, I can see how, and actually, I would agree that there needs to be a strong legal end on the back end, whether it's just some type of acknowledgement by the court once the paperwork comes through, just kind of like a birth certificate or a death certificate, how it's recorded through our legal system. I'm not saying that's the example, but thank you. That really hit home with me then. Thank you.
Yeah, I think there needs to be a legal outcome.
And Your Honor, I think that our Vice Chairman makes a great point, and I was reading a case this morning about where that was essentially the situation that our Vice Chairman just described, where there were two parents acknowledging the parentage and registries and everything sort of appropriately. Do you see a possibility of we'll still go through the courts, but maybe almost we have all this here, we can streamline the process through the Superior Court?
Yeah. I mean, one way I think is through greater outreach and education in the community because, you know, not all, we've been sort of dealing with hypothetical where the legitimation is contested, but not all of them are contested. Just as you can get an uncontested divorce, you can do an uncontested legitimation. And our legitimation station is set up to do those and does do those. So that's why I say if they agree, there's no reason that they couldn't go to the legitimation station and sign a consent judgment and have the child be legitimated and have it signed off on and approved by a judge, assuming it's in the child's best interest.
The case I was reading, interestingly enough, was exactly what you described. And 6 years later, when the couple split and the mother wanted to remarry, the father pursued legitimation, and it was denied at that point, but then it was overturned. And so I thought it was interesting. So they had everything in place except for the legitimation earlier in the process.
And that's why it's so important to take care of it early in the process. That's really, I've seen those cases as well, often in the context of an adoption, where the mother will marry and it's a stepfather wanting to adopt the child. And at that point, the father, he may have been a player all along, but sometimes he hasn't been involved in the child's life. He's entitled to notice in that situation under the law. The laws of this state say that he's entitled to notice. And how that notice is given depends on the relationship that he's had with the child. The statute says that it's not subjective. It's not just, oh, I really want to do this. It has to be matched with some action on the part of the father to show that he's tried to develop a child. And then the notice can be, the lowest form of notice, if I recall the statute correctly, is service by publication. But generally, the preference, if the child, if the father is available and on the scene, is personal service, personal notice, so that he's served with the paperwork and can go in and contest his rights and seek his rights. So usually where I've seen that happen is in the context of an adoption, where the new father wants to adopt.
It almost sounds to me, and I don't mean to cut you off, sir, but it almost sounds to me like there should be a mechanism within our process or our recommendation that offers the same type of rights that an owner has when there is a piece of property that's transferred. So when you take possession of that property, you immediately have to go to the local tax commissioner and file your homestead. And then you go to the tax assessor, and then they appropriately make sure that those documents are filed in the courthouse that reflects ownership has now changed. But there is a device internally within that municipality that checks and balances that this process has been met. And then there is the responsibility that's laid from the beginning. Who is now saying that they are in possession or responsible at this point? That, from what I'm hearing, not saying that people are property, but we have a more stringent process as it relates to that in some form we could modify, apply to that whole process about legitimizing the birth, in essence, making sure that the father has his rights at the time of birth, because you can't come back later and say, just like in the property process, and say, well, I bought this property, well, where did you file it? What does the courthouse say about where that is recorded? And it's a very clean process that we have made modifications through in the legislature about, who can, file a deed against your property. All of that is tracked within that court filing system. And it appears to me that we have a process that could, in essence, be emulated or mirrored but us taking some time to figure out how we can apply tools that we already have without having to wait 4 and 5 years and creating all of this trauma for families and children and parents, where we could really fix that at the front end.
I'd like,
Just to add, oh, I'm sorry, go ahead, Rob, because
I'd
I've
like
been
to
talking.
add on to the front end solution. I guess in my mind, when two individuals sign a birth certificate, that birth certificate is saying who is the mother and the father. If a child is born out of wedlock, even though the father signs that birth certificate, from what I'm understanding, that does not make him the legal father.
That's correct.
So explain to me why we, and before I make that statement, because the statement might be harsh and I don't mean it to be harsh, I'm under the assumption that there's a fair amount of this of individuals, fathers that have signed the birth certificates that believe they are the legal father, and they're not.
And
So
that's-
why do we allow them to sign a birth certificate at birth if it doesn't give them that ability? When my hope would be not allowing this would trigger them, I would like to sign the birth certificate on the father. Well, I'm sorry, you're not married. You need to go through the legitimation process. And that way at the very early end, the birth of this child, fathers are being informed you are not legally the father as the state sees it. So what is the harm or benefit of not allowing a unmarried father to sign a birth certificate at birth?
Of not allowing?
So at this point, we would change, I guess I'm going through the idea of us not allowing the father at birth to sign a birth certificate if he is not married.
Well, that's out of my league on that one. Not only from a subject matter standpoint, but just from a judicial standpoint in terms of, again, I follow the law as y'all give it to me, and judges generally do that. But I agree with what you said at the very beginning, that there are quite a few fathers who believe that because their name is on a birth certificate that they have some legal rights. And, I think that that's where the education and the outreach, at least on our end in Columbus, come through. We spend a lot of time trying to dispel that notion and letting them know that if they want to participate as a parent and, be a co-equal in raising their child, they do have this remedy. And if the mother's fully on board with it, it can be by consent. She can just show up with dad at the Legitimation Station and sign the paperwork there. But I agree that misconception is out there, and I would also agree that it's very common because anecdotally, I see it, and I think most judges see it in our courtrooms.
Representative Clifton, I think that was, an exceptional point that you just made. And, it gets down to the foundational question of, if the signature on the birth certificate means nothing, why are we allowing it? Because it only creates misunderstanding amongst fathers. So I see it as two options, though. The option you articulated was to allow them to sign legally, but the other option is make that signature mean something. If somebody's there and willing to sign it and articulating to be the father, and I think we can biologically prove through DNA testing that he is the father, then the judge just made a very good point. And Judge, you really opened my eyes on something that I'm so glad you could be here today. I've been looking at this as one process, but he articulated it today as two. There's really two alleys. There's uncontested petitions and there's contested petitions. An uncontested petition where the mother and the father are agreeing at birth, in which an action of uncontested is she's allowing him to sign the birth certificate right there in her presence. And if they go through that test, there should be what was the terminology? I'm an attorney, I should know this, but you said not a summary, you said
consent judgment.
A consent judgment. That some type of basic consent judgment form should be available for them to sign at the same time they're signing the birth certificate to just go file with the court. and now he's the father because they all agree. And that adds the legal component to it that the judge was talking about. Now, when it comes to the contested, when, you know, a father's claiming I'm the father of that child and the mother is saying, no, you're probably not, you know, of course that needs to be in front of our judicial system. We cannot resolve that instantaneously. And so, thank you. I like the way that you make me think about that differently. And thank you, Judge, for giving, you know, me insight to the two tracks. And I know you got to go. I know you got Cordy, you got people waiting on you. And I've always known you to be prompt.
Well,
So, yes, sir. But, Mr. Chairman, if no other questions up here, I suggest we.
Absolutely. His comment was an interesting comment for a different reason, because it does say that's where education would begin, right? As opposed to, we're all excited, we're in the middle of all that's going on at the time of birth, and oh, by the way, sign this, and people probably sign all kinds of things, and so, of course. Well, that would be exactly the beginning, or the opportunity to begin the education, to say, there's a lot that goes along with this if you want to have legal rights as a father. I'm still wrestling with the idea in my head, just sensibly, that someone thinks that if they go through legitimation, they might have to pay child support. For me, the issue is, well, they have responsibilities as the father, the biological father, for child support, but not necessarily the rights that go with the biological father. And that's like, it feels like, and someone asked me the other day, shouldn't the burden be on the courts to say you don't have the right to be the father, as opposed to the father asking the biological father? And I thought that was a fair question, and I've gotten all kinds of feedback on that question, but.
Well, you know, we can only rule on a case of controversy that is before us. You know, we can't step in preemptively to solve problems. Somebody has to file something and bring it into the courtroom before we have authority to act on it. And, you know, the legitimation process, as I was discussing with Representative Reese, it can be as streamlined as the parties are willing to make it. And if they're in agreement, you know, it's just a matter of where you physically are when you sign the paperwork. Now, a judge would still have to sign off on it and approve it and make sure it's in the best interest of the child. And some judges want more evidence on that point than others do. Yeah, a lot of the framework is already here, and I guess I would, if I had to leave the committee with one thought, I would say whether it's signed at the hospital or whether it's signed at the legitimation station or whether it's something they research on the internet and sign at home on their kitchen table, there should be some judicial oversight of the process. Much as it would be if there were a divorce, if we were looking at the opposite situation. These key moments in a child's life, I think it's always good to have a neutral third party, such as a judge, take a look and make sure that this is in the child's best interests.
Yes, sir. And given the length of and the breadth of your experience, I read you loud and clear and agree with, and that makes perfect sense to me. But we can't thank you enough for being here today, Your Honor, and thank you for leading the charge in our state with the Legitimation Station. It's very exciting, and it feels like a cornerstone piece of what we ought to be thinking about to help spread the word around the state.
Well, I appreciate being invited, and I'll be happy to respond individually if any of you want to follow up with me. So, thank you. It's good to see you.
Thank you. Okay, next on our agenda, we have Mayor Kenneth Sumter, Fort Gaines, Mayor of Fort Gaines, Georgia. Thank you, sir, for being here today. Please tell us tell us about yourself. You gave me a good explanation about the pin on your lapel, and I thought it was interesting. I bet others would find it interesting too.
Okay, I'm Kenneth Sumter, Mayor of the City of Fort Gaines. Been mayor for about 6 years and up for re-election here this shortly. And we shall see how that comes out, but I anticipate the best. I'm in Fort Gaines, is about 70 miles south of here, right on the Chattahoochee in Clay County. And so a small community is Fort Gaines and Clay County as well. Some would say, you know, we're still part of rural Georgia and claim it proudly. I tell people from Atlanta, we feed Atlanta, so don't push back too hardly. But my background is in development, design, build, real estate, as well as telecom. Kind of broad brush there, but it all works together somehow. But I'm pleased to be here. My friend, Representative Reese, and I were speaking a couple of weeks ago, and I had no concept of this legitimation instrument, and so he was making me aware of it as I was sharing some of my story. And he saw it essential that I be a part of this discussion. I'd be pleased to contribute as much as I can. So the legitimation process is, like I said, is a new concept to me. I see the value in it regarding fathers. Been, as the judge has said, so much outside of the picture. Particularly, I would speak to the position of the father after the divorce, more so than confirming his legitimate fatherhood. But it was curious to me as it was being presented that once the father is proven to be legitimate, then is the family then free to be a family, or does that lead to the child support system being engaged further after that legitimation process? Let the family be a family. Now that he's proven to be father, let them do the parenting thing and build a family. The idea of the court system can, an outsider, a third leg in a two-party relationship, directing the process of how a family should operate, whether the father or the new father has some, he recognizes his financial obligation as a parent, and without the need for the court to monitor that process. Parent, and life is life, just do what you're supposed to do. Now that we've confirmed you as a father. But I see, my perspective comes from after the divorce. So now you have a family that is no longer the father and mother, parents are separated. And I find that the court system being engaged now in that process has a tendency to delegitimize the father in that process. Essentially, also, there's some degree holds him, the children at ransom. The court continues to say through the child support side, we have the children's interest at heart. And the best interest of the child, well, that's debatable, whether that's achievable through the court system or through this legal process. I've had the experience over the last 10 plus years to be engaged in the foster system as well, through a friendship, and found myself to be a foster parent to more than 30 kids over a little more than 10-year process. That side of the experience is good. I'm known to papa by several of those children, but within myself, I still challenge, curious about on the child support side, and on the foster side is one side of the house, and they say, well, we have nothing to do with that other side of the house. But then I see the effort on the foster side to maintain the relationship with the mother, and bending over backwards to retrain if she has abuse issues to make sure that's cleared up. But then not so much when it comes to fathers. We're just outside of the system. or we're not outside of the system. There seems to be the effort to keep us inside the system and to burden us with more responsibilities to the point of being criminalized, but with the same expectations. So so on that side of the equation, where the father about doing a divorce, where now the father is challenged now to maintain a relationship with the children, and under direction of the court. I'd like to go back to this movie, Ms. Doubtfire, which gives a good example of what happens when a divorce happens. Here's a father who expresses that my children are the air that I breathe, but yet the court decides by what rules you play, changing your employment, meeting with supervision your children, to the point where he has to create another identity just to have an unsupervised relationship with his children, because the court now becomes a party when two people who have now divorced. So now so it brings more confusion. But in this case, you see where the remedy came back to the mother, custodial parent, who agreed to allow access to the children without the court. It was her decision, not the court's decision within this movie. And I see that is not necessarily the case so many times in real life, where when the father is delegitimized because of divorce, the mother many times keeps the father at bay.
Mr. Mayor.
Go ahead.
So you're the mayor of Fort Gaines, which is, for those that don't know,
What is that?
here today, it's down in southwest Georgia,
Southwest Georgia,
along the Chattahoochee River,
yes. On the Chattahoochee River.
right across, and right across the river is Alabama.
Yes.
And historically, your city was the state line between the state of Georgia and the territory of Florida.
Florida,
So it's a
exactly.
very historical city with an old fort down there.
Yes.
So when you think about the complexities of the economy and economic development and growth down in Southwest Georgia, when you look at this issue here that we're talking about right now, legitimacy, do you see a high number of young folks in your area that lack the father relationship or born out of wedlock, as the judge, I think, said 52% here in Columbus?
Yes, there's a high rate, yes. The high rate of their fathers or young women who don't have their fathers actually involved in the lives of the children.
Okay, all right. And do you think that a more streamlined process or a more direct process at the state level, giving men an opportunity to have a more legal say-so and the raising of their children would engage more fathers in your area to do so and be involved in their children's lives?
Yes, it's become a legal question. Again, the judge yielded to you at the legislative level, say, well, the law is on, it's up to you to create the law. Mm-hmm. Yes, it becomes a legal question when again, fathers who are separated or not involved in their children's lives would have to engage a lawyer in order to get some sort of resolve. Again, it's always a cost.
And that's money.
Yeah, it's money.
Yeah, that's
typically,
money.
yeah,
Yeah.
on the father's side,
Yeah.
and not so much on the mother's side. So
Yeah.
The burden is high.
And considering that it's possible for a man to be required to pay child support, but still not have the full legitimate father rights of like a husband when a child is born through marriage, considering, again, just a normal Georgia community where you live, sometimes, folks in Metro Atlanta oftentimes don't quite understand the complexities of what happens in rural parts of our state, and that's really what I wanted you to, and that's what you're leaning into today. That's what I wanted to hear. But when you think about a man who may already be on child support, and then trying to sustain his own household, where is he supposed to get this extra money to pay a lawyer to legitimate a child so that he could be a part of that child's life? To me, it's like we're almost asking someone to take on an extra burden to be responsible a little bit more on this end. Now, as a father of an 8-year-old, to me, it's something I desire to do. It's in my heart to do, right?
Not to say that most fathers, I think, would want to, except for the court many times by demand. And like I said, in many areas, even though this is rural Georgia,
Yes, sir.
The cost of living is different. The availability of employment is different, but people are still people. And so the idea of meeting that high bar, or that bar that's established by the court to be engaged with the child is sometimes a strain.
Yes, sir.
And so now the court has to make some decision, because essentially the father might be at default.
Right, right. Well, thank you, Mr. Mayor. That's all I have today, and I really appreciate your presentation amongst us today and your testimony about what's happening in your part of the state with fathers there in that area. Thank you so much.
Thanks so much.
I'd like to take a second to introduce Representative Vance Smith. Representative, would you tell us a little bit about yourself for the folks that may not know you, although I imagine most people do know you, and after your many years of great service to our state?
Come on over.
Well, we're about to get you fixed up, Van. So while we do that, I'm just going to say how wonderful it is to have another Columbus person here with us today, because it's just one button, Vance. Okay, walk down this. You go down the ramp right here, and then go to the right, and you're going to walk out the door. As soon as you walk out the door, you see the restroom right there in front of you. Representative Smith, I was being surrounded by some people from Augusta here who had some pretty lively things to say prior to your arrival. So I'm glad you're there to provide check on that and balance on that end of the room. Well,
Yeah, okay. Thank you, Mr. Chairman, and thank you, Representative. Sorry, I'm a little bit late. We had a groundbreaking for Columbus Technical College, the Vector Center down near Fort Benning. So I was both at the same time, so I appreciate you allowing me to go to that and then come over here. I represent District 138 in the Georgia House. I have a northwest portion of Columbus, Muscogee County, and the Green Island, Brookstone, Double Churches area. I represent about 80% of Harris County. I live in Harris County. And then I also go up into Troup. I have about 40% of Troup County all the way up to Heard County. So long distance, about 68 miles from one end to the other, but happy to be here. We had a great meeting in Atlanta, a lot of great testimony. I know y'all have heard great testimony here today too, and then we have our final meeting in Augusta, so look forward to being on time for that meeting, Mr. Chairman.
Thank you, Representative, for being here. Mayor, didn't you say that you were on a board of a technical college?
Yes, Albany Technical College.
Well, that's a fun coincidence that he just left a groundbreaking, and as chair of this committee, I'm also very proud to be the vice chairman of higher education, which works with our technical schools, so thank you for that. Sure. You said you were a foster parent at one point, right?
Yes.
Had you ever heard the term legitimation before?
Not until I had the conversation with Representative Reese recently.
Okay, thank you for that. Are there any other questions for His Honor, the Mayor? Thank you, sir, for being here and your insightful
Thank you very
feedback
much.
for our committee. Thank you.
Mr. Chairman, as he exit the chair, I just want to say what great work he's doing down in Southwest Georgia, trying to bring in a lot of energy and innovation to a part of our state which has been so challenged, not only from a healthcare perspective, but an economic development perspective. And it adds an extra level of complexity to the families in that area when we talk about issues like this. And we have to make sure that we layer it appropriately so that people all over the state know exactly what we're dealing with. So thank you again, Mr. Mayor.
Surely. Thank you very much.
Is Mrs. Porter here today? Sharonda Porter?
Oh, well, yeah, she waived. She waived. She waived.
Oh,
She's gonna pick
okay.
up the investor.
Okay, perfect. Thank you, Mrs. Porter, for that. We have do we have other people to speak today on the sign-up sheet?
The presentation. Yeah, 4 people. We have the presentation.
Okay, Meg Murray, please join us. Please introduce yourself. Tell us who you are and where you're from.
I'm going to go ahead and give you these just in case I forget something that I'm looking to today.
I can pass them out.
Oh,
Yeah,
okay.
that's my job.
Thank you.
Did we get you set up?
We serve many roles.
Did we get her set up?
I am supposedly set up.
Okay.
Tell us your name first and where you're from.
Let me just make sure I got all the,
Okay.
All right. My name is Meg Murray. I am a doctor of information systems, which you all would know is computer science. But I'm here today as a board member of Equally Present. Equally Present is an organization that educates and advocates for the full and equal involvement of parents in their children's lives when the parents separate. I got involved in this work as a result of my son's custody case, and I will just say that my son's case is not characterized by the trust, the integrity, the justice, or the fairness that we are taught our legal system has, or that my husband, a disabled war veteran, fought for. But I'm not going to talk about my son's case. That's for another day and another time. What I want to talk about is what I have learned over the last 6 years of working in this area. I have worked with numerous dads, moms, legal profession, other advocacy groups to study this and to see if we cannot do something to bring change, a positive change to this state for our children, our dads, our moms, and our communities and our society. They said they had my slides, but I don't see them. They got them? What I am going to tell you today is what we see, we the people on the other side, not say the judges who are carrying out the legislation, but how we see the legislation, how it has impacted the families in terms of how they understand it and how it's carried out. This is the way that parenthood works for dads in this state. And the term gauntlet is an appropriate term. It's actually a very 3-step process. You have paternity, and paternity pretty much establishes who the father is, and you've talked about that. You know, you have the physical, but you also have the agreements, because there's adoption, there's all kinds of things. But the establishment of paternity, what it buys you in this state, OCGA 19-7-49, it gives you financial child support, absolutely no rights at all. So you take the next step to legitimation. What legitimation gives you is the right for the child to inherit from the father. I understand the term legitimation was used a lot by the judge, and it's used quite frequently. I think they combine it to mean legitimation and custody. In the state of Georgia, when a father goes for legitimation, he also at that same time has the right to ask for custody. Custody would be your legal rights and your physical rights.
So just to make sure we're clear, when someone is married, the father automatically gets all 3 of these?
He gets all of those instantly.
Okay.
And while we're on that topic, I just want to mention this. The numbers that I have, and obviously Muscogee has numbers for their area, for the state, or about 45% of the children in this state are born out of wedlock. And I just want to point out, that's not going to change anytime soon. It's been a pattern for a long time, but it's going to increase. In my role, I am also a professor, and I can tell you, millennials, Gen Zs do not get married. And I will tell you why they do not get married. They aren't going to get divorced because of what it costs. So we are going to see a lot more children born out of wedlock into families. My son's situation, was a family. So let's see if I can do this. So that's what happens. But here's what it ends up for a lot of dads. And again, I have worked with many dads, and dads aren't trying to get out of paying child support. I realize, if you want to know the numbers, something like 70% nationwide don't pay child support. And that number one reason they don't pay child support is because they don't see their kids. So anyway, in this state, what happens is that as soon as the child's born, the mother gets total and complete 100% rights, and the father has nothing. What the father has to do, and it's often at great expense, and that expense is obviously on a continuum. $200 is a lot of money for a lot of people. But then you add in lawyers, and that fees can start getting really, really high. And so the point I want to make here, and I want to leave you all with here, when you're thinking of what can be done to make this better, is that when you give dad paternity, you give dad legitimation, you don't give him parenthood. I call it a bank, not a dad. And that's what I use in this next term. And the really difficult part of this for those of us who believe in our families, which I think we all do, is that what the research shows. It shows incredibly starch data. Children raised without fathers do not do as well as children who are raised with fathers. I just saw something that came out. I don't know if there's some political pundit here in Georgia who has a weekly podcast, and he just came out and said that in our state, and actually is reflective in the nation, we have a lot of depressed children. The number one depressed children in this state are girls who do not have the involvement of their fathers. So, Representative Reese, which is why my son has cost him almost everything he ever had to try to stay in his child's life. The other thing that the research shows, and remember, I'm a researcher, so I follow this stuff. The research shows consistently over and over again, children who have equal access to both parents, when those parents are separated, do just as well as children who are raised in a two-parent household. So the thing whoops, did I go backwards? And this is something that I've heard a theme in this room mentioned, and this is the idea is that you can call it, for mothers, motherhood, parenthood's automatic. For dads, it's conditional. As soon as a child is born, we're going to assume the mother's a fit parent, and we're going to make the dad go through a bunch of steps to actually be a father, to be able to carry forth his parental responsibilities and his inherent right. And so I want to ask a couple questions when I stop here. One, I know you have a child, Representative Brace, a young child. Think about what would happen if you were in a situation where you ended up split. Why would you have to defend your ability to parent over the mother? And then I'm going to ask Representative Hefner this question, because you mentioned the military, and I've worked quite a bit with the military, because as I mentioned, I'm married to a disabled veteran. When a guy gets deployed in the military, and he comes back after a few months of deployment, and his child's mother has decided that she prefers a different fella, they say to him, oh, wait a minute. You haven't seen the child in 4 months. You haven't spent a night with that child in over 4 months. You're going to have to show to us that you can be a dad. Or, I'm going to be really direct here because I've seen this and it's heartbreaking to me. They're going to say, well, you got PTSD. Well, I want to ask the question, when a mother comes back, do we ask her those same questions? We do not.
I completely understand your point. As a matter of fact, some of my first questions on this committee were regarding individuals who were serving on deployments. I'm a military veteran, having served myself, but I currently have a son who was in that exact situation. He has a daughter, and he is stationed in Jacksonville, Florida, and she lives here in Georgia in another location, different location from him. We are presumably looking at the possibility of a deployment for him. Some of the concerns that I have raised come from the purview of that specific circumstance. Now, to your point, you're absolutely correct. When I was stationed overseas, nobody asked me about whether or not I could prove that I had the skill set or the bandwidth to now support and raise my own son. It is a variable that should be considered, which is why I believe my participation in this study is so relevant. I bring a specific purview to the conversation. Understanding what PTSD looks like, understanding what that looks like in families and how that plays out with them now being reintroduced into that setting, and all the dynamics that come with what they call absentee parent, which is, it doesn't apply to individuals who are serving their country. It should be a completely different category for them. And so, to your point, I'm answering your question with a profound respect for understanding the circumstance that you face. Please accept my sincere regards for your work and your experience. It is not just falling on ears that I'm just here to hear. It comes from a perspective that understands that we have to have language that addresses that. There are too many active duty military individuals in this state for that demography to be unchecked. We can't have a conversation where that data is not presented because it is absolutely relevant. Thank you very much for your work.
And again, what I'm trying to achieve here is to just give you some ideas and understandings and things to think about. And I will close it with some ideas of some suggestions. But basically, it is a very complex issue that you're dealing with. I realize that, because we want to do what's the best for our children. But we tend not to, in this state, we tend to forget that our kids have two parents. And you've heard that repeated over and over. And we tend to push this narrative somehow that dads aren't as good a parent as a mom. And I'm going to contest that and say that's not true. And I'm a woman, so I feel like I got a right to say that. Parents may be different, but that's good. Good for kids. They need both sides. And that's what we're trying to achieve here, is to make sure both sides can be there. And what happens in the state, and this is what this next one's talking about, is really, in Georgia, if you look at what happens in Georgia, the most common thing that happens is the parenting plan known as the Disneyland Dad. Every other weekend and 2 weeks in the summer. That does not make a dad. That makes a visitor to the child. That's why they call it visitation. And I want you to think one step further than that when you talk about this every other weekend and 2 weeks in the summer. That's 4 days a month. If my son sees his daughter 4 days a month and I want to see her as well, now he doesn't get to see her 20% of the time. I can't interfere with any parenting time my son has because he has so little. So now my grandchild loses out completely on the paternal side of the family. In Georgia as well, this state has, we study this in Equally Present, we study the child support situation quite steadily. Georgia's child support is pretty high for lower income dads. And we are also one of the states that incarcerates men more frequently for not paying child support. So you see there's what I put here, a high cost for little time. And again, I mentioned it before, but the data is all out there. Dads who see their children pay child support. And what ends up happening with these situations is the kids lose. And the other problem we face here, and I realize this goes well beyond paternity and legitimation, but as you're coming up with a solution for, even if it's just that portion of it, you keep the broader conversation going to think about. Our legal system, I'm not an attorney, so correct me, but our legal system is built on an adversarial system. That doesn't work well in family. Because what you see happens, and I go to court, I'm a court watcher, I go to court quite frequently, what you see is parents are pitted against each other, even if they don't intend to be pitted against each other. It's just the way the court system tends to make it play out. We have this mentality of a winner-take-all system. There's no winner-take-all on mom or dad. If a mom gets 80% time, she doesn't win. The dad doesn't. I mean, that's not really the way it's to be looked at. The child loses. And what happens down here is the last line there for the dad. I have seen it for a couple women, but I've seen it for many, many dads. It's really a dad thing. They face these legal costs, steep legal costs, and exhausting battles. Many of them cannot afford to do it. They can't afford to do it financially. They can't afford to do it emotionally. You have to realize they're making choices here all the time. If I put this money into fighting to get my child, to make sure I'm a dad to my child, that money then comes away from the child's financial stability in the future. And no, my granddaughter no longer has any form of a college fund. So I'm going to go to the next one, because this one is the one that I don't hear people talk about, but it's a very serious one. And it's the legal fees cost. It's a huge barrier. And I realize the solutions aren't simple, but I can give you a couple solutions that don't fall underneath your study group. But I'm working on it. I'll keep giving these to the head of the judiciary committees. In fact, they're in federal court. And that is, in this state, when you go for custody, we do what's known as a statutory fee shifting. You go in, and you are a dad, and you ask for more than every other weekend and 2 weeks in the summer, and you lose, you're very likely going to end up having to pay the mother's attorney fees as well as your own. When I presented before the governor's staff and Child Support Commission, this was their biggest concern. If dads get hit with their fees, they get hit with the mom's fees, how are they going to pay child support? And by the way, I have seen this many, many, many times. The legal fees are used as financial coercion, and they pressure fathers to walk away. And I'm not going to say too much more about this because of my son's case, but I will say this. This is advocated for by some very high-profile attorneys in this state. One of them wrote a book, page 34 to 38, recommends that moms use threats of attorney fees to get dads to acquiesce and go away. These attorney fees should not be allowed for a couple reasons. One, you basically are crippling the dads for trying to do the right thing. And the other thing is they are unconstitutional. Again, you can read the federal filing. They're a violation of the First Amendment, several portions, and the 14th Amendment. But what they do, again, when we allow these things to happen, where we don't just make assessments that both parents have rights to their kids from the day the child's born, if they agree to it, it's the kid who's going to lose. So, where do you look for answers? I don't have the answers. The suggestion I would make, though, is that you make something more automatic when a child is born if both parents agree and they sign the birth certificate, because dads do not know about legitimation. And yes, the hospitals give them this sheet that is, I don't even understand it. And my son was never given one, by the way. Sometimes they forget. And they've never heard of legitimation, just like you heard the mayor say. That really needs to be fixed, and education's not going to do it alone. It needs to be something more. I mean, if you're going to give them a consent form in the hospital, that's an idea, but something where they know immediately, they're told by some official that it has to be done. But if you want to look for guidance, you can go right to the Georgia law. Do you all remember the Parents' Bill of Rights? You all passed it not too long ago. The Parent Bill of Rights declares parental rights are fundamental, and it declares parents' rights. It doesn't say mom's rights. It doesn't say married parents' rights. It says parent rights. Both moms and dads have a fundamental liberty interest in their children, and it is equal. Granville versus Troxel, if you're a Supreme Court person. And the whole point of the fundamental liberty law is that if you're going to violate a fundamental liberty, or you're going to challenge a fundamental liberty, you can't do it without applying what's known as strict scrutiny. And this goes for legitimation as well. The best interest of the child standard, which there's a lot written about that. But if you're going to look at the best interest of the child standard for legitimation, you need to, if you're going to deny legitimation or deny custody, which I realize is the next step outside of what the study group is doing, but if you're going to do that, right now, here's what we use as our standard. It's called any evidence. I bring forth any evidence and I can reject your legitimation standard. What it should be is strict scrutiny, clear and convincing evidence that legitimation should not be allowed. And then I'm going to point you here to what our neighbor has done. I know we're not Florida, but if we beat them in football this year, maybe we can all look at this, right? They passed something called the Good Dad Act. And basically what this act does is at the birth of the child, it immediately makes it such that there has to be brought forward a parenting plan, a time-sharing schedule, and a child support schedule. So in other words, they combine the idea of paternity, legitimation, and custody into one step when a child's born, rather than a three-step process. And I would hope that if we can't do something that's great, that at least we could combine the first and second step to make it more automatic for dads to get some kind of rights to their child as soon as the child is born.
Can you speak to, I'm Can you speak to the actual, and we got about 2 minutes, and then we need to get to some speakers. Can you speak to the actual operation of the Good Dad Act? I mean, I know what I see what's up here, but how does it actually works?
How does it work?
Yeah. Like two people come in, have a baby. And I guess they're agreeing that that this baby is ours. So we're talking about a uncontested.
Yeah, so uncontested, right. And
All
then
right, so it's
they make
uncontested, okay.
They make an agreement.
Okay, and so do they fill out paperwork there at the hospital?
I don't know if they give them to the hospital or
You don't,
not.
okay.
I can
okay.
find that
We
out.
can look into it. No, but if
Yeah.
you want to share information, that'd be wonderful too. That's the kind of operational details we need to understand. Like, I like, that sounds good on his face. And I would love to learn more about it, and Mr. Chairman we just said that, but I just need to know kind of layer by
Okay.
layer how it works.
Well, here's what I would like to offer. I contacted the Good Dad Act people. One of them is now a judge, but I did not want to offer your names or your information to them without your permission. I thought that was a little going too forward for me. So if you would like, I can get you contact information, and they would be happy to share with you how they implement the Good Dad
It would be
Act.
great to get them to Brock, if you will,
To,
Brock Perry,
you give me your email?
and if they feel like making a field trip, they can join us in Augusta. Or maybe, if they can't make the trip, we possibly can do something maybe via online, because I
Okay.
think we've spoken to people before off-site.
Do you have that date? August, I forgot it.
The Augusta meeting?
You'll find it.
Yeah, we'll find it. Well, that's some good information. I didn't know about
But
that.
here's what I'd like to just to leave you with, though, is that we really do need to do something to make this, to give fathers involvement and participation in parenthood when the child is born, rather than just looking at it as a financial transaction. They need to be involved. And it's more important for our kids than anything to move forward with more involvement of both parents in the child's lives.
Mrs. Murray,
Yeah.
a lot of the, your comments and on the expense side, those are probably more nearly related to custody issues than they are to legitimation issues, I assume, right?
No, because what I understand from what this Judge McBride was saying, okay, and from what legitimation term I hear used, it combines the two, all right? Typically, today, when you go for legitimation, you're also arguing for custody. You're not doing it separately. There's not a whole lot of point for a father to go for legitimation alone, because it doesn't give you any kind of time with your child.
I really appreciate your perspective as a grandmother.
Yeah.
Who would like to see her grandchildren more. We haven't really heard that perspective yet until today. And I think it's invaluable, because how many grandmothers and grandfathers out there would love to see their grandkids that are not getting access? So that's hugely
There
important.
are
And thank
a
you
lot,
for your
but-
incredibly thoughtful presentation. We'd love to have a copy of that as well, if you don't mind.
You mean electronic?
Oh, I have it here?
Yeah.
Gotcha.
But,
I'd love to have an electronic
again, I'm
version
going
of
to
it.
say, yes, I would like to have a more time with my grandchild. But my fight here is that my child has time with her father, because that is the important relationship. And from that would build the external. And I think a lot of grandparents, are trying for that. But it is a point to take out. When you give a kid 20% with the dad, they lose their dad's parents.
A last request from you, Mrs. Murray. I'd love to have an electronic copy of your presentation, just so I can, if I want to share it with someone, with our legislative counsel or anyone, I'd love to be able to email it to them.
Email it to Rob.
Mr. Chairman, I would like to thank Ms. Murray for that presentation. It was very succinct, very detailed. It got to the point real quick, and that's kind of what we need sometimes, is that comparison. And just to be absolutely clear, there can be expenses associated with legitimation, especially You know, here in this region, we're fortunate we do have the Legitimation Station for those who can attend, which kind of breaks it down for them and give fathers the original paperwork to file. If you're not in Muscogee County or a part of the Chattahoochee Judicial Circuit, then you have no idea how to do that, unless you're working with like Fathers Incorporated or some other entity that has, you know, ventured into this field, this area, because of the complexities in our laws. But someone else is totally lost, and when you don't know what to do in the legal sector, what you do, you go hire an attorney. So now we're talking about attorney fees, and we know that's not gonna be $5 and $10, that's gonna be possibly in the thousands. And so this process can have a financial burden on a father throughout the duration of it, and certainly depending on how long this is gonna last and how much research has to be done and things of that nature. So just wanted to add that a little bit, but thank you again, Ms. Murray.
Certainly, you can streamline it, make it simple for those non-contested.
Yes, 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 and that's why it was so great that those two avenues came out today in the conversation. The potential, you know, the uncontested petition and the contested petition. And I think in the course of the conversation, Mr. Chairman, it's gonna be important that we identify those two routes, because it's oftentimes the contested petition that has the most complexities, but that's holding up the uncontested side. So I think we can do better and not let great get in the way of good, right? And actually do some things that's going to be beneficial for our state. And I think we've heard some great testimony today. The revelation from Representative Clifton there, what he shared with us earlier too, about that signature. You know, I like the way you broke that down to me. And after you said it, you know, I was sitting here saying to myself, you know, it is actually kind of cruel as a state that we allow someone to put their signature on a document that does absolutely nothing. Absolutely nothing. And that's where we are right now in operation of law.
Mr. Murray, thank you for making the trip over, and your passion is, and your time and effort on this is certainly obvious, so thank you for being here. We have one last person that we'd like to hear from today, Carrington Buzz from the Barton Center at Emory Law School. Mrs. Buzz, thank you for making the trip. Very happy to see you again. Hope we'll see you in Augusta, too.
Good late morning. My name is Carrington Buzz. I am the postdoctoral fellow at the Barton Law Policy Center. I just want to preface what I'm about to talk about, saying that these are my views based upon. Oh, sorry. I'm sorry. I'm dumb.
You're fine. No.
I'm sorry. Do I need to? You heard me. The views that are going to be expressed are mine based upon training and experience and research, and not those of my employer. So first, I want to address the question that Representative Clifton came up said about why do we allow this signature when we know it attaches no legal rights. There is a ceremonial aspect, but most importantly, it's because of federal law. Title 4D requires states to have this administrative procedure for establishing paternity, because paternity attaches child support. So that's why this administrative form is available for a father to then assert paternity. It's for Title 4D and child support reasons. That's why.
But it doesn't assess paternity at that point, because if they're married out of wedlock and there is no DNA test done, there's no way to know if that father is the paternal father. So they're signing something that is saying it's paternal, but there's no evidence, and I'm assuming lots of situations where it is not a paternal father.
There are instances where somebody can sign acknowledgement of paternity and they not be the biological father.
It's like Ms. Murray said, it's the bank. Once you sign it, you become obligated to pay child support, but you don't have any rights to visitation. You don't have any rights to go down to the school to talk to your teachers about your child. If your child is laying up in the hospital sick, you have no rights to tell the doctor that you want them to administer life-saving measures to keep your child alive. You have no rights, but you are responsible to pay. That's what paternity means here at this level, and that's why she broke it down to saying we have 3 different levels. You have paternity, legitimation, and custody. And in Georgia, all 3 have different levels of rights that they give to the father. Paternity basically means you now have a right to pay child support, and that's it. Representative, that's all that comes with that.
Well, didn't we hear testimony on the first meeting in Atlanta about a couple that were not married and they had a child, but a third party, another gentleman came in and actually signed the papers like he was a dad? I remember hearing that.
That was me.
testimony.
So legally, if a individual, a male for this conversation, signs the certificate, is he legally paternal? Is he legally the
Paternity
paternal
has
father?
legally established paternity.
So paternity is legally established at that point in time without, I guess, a DNA backup.
Right, and I will say that there is a legal mechanism where within 60 days you can rescind it.
Okay.
But if a father signs an acknowledgement of paternity, paternity is established legally
Okay.
without rescission or anything like that.
So then
And
somebody has to challenge it, the actual father has to challenge that in court and has to go get evidence to prove that he's not the father?
yes, it creates a rebuttable presumption. I gave you all a one-page handout because we're talking about how do we address this, especially for cases without a controversy or that's out for that's being contested. Last time I spoke very briefly about the Universal Parentage Act as a way to streamline cases that are not subject to controversy, which means two parents are consenting to this parent-child relationship or this parent-child dynamic. What I did with this one-pager is, because the UPA is dense, it is very dense, I took out some of the key provisions that address the acknowledgement of paternity that is addressed in the UPA, just to kind of give a breakdown of what this act could do, or at least adoption of parts of the act. The Universal Parentage Act, it can be taken or adopted in its totality or in pieces from a state. Just a very quick overview of what this does is, and kind of going back to last time, in the late 90s, the federal government had a very large push for establishing paternity for reasons of child support in Title 4D. And Georgia, at a certain point, had a law that connected paternity and visitation rights. Those things were in connection statutorily. I do not know what happened or why they weren't attaching, but when administrative legitimation was repealed, that section was struck from the law. So what other states were doing in that time is that in doing this acknowledgement of paternity, they were seeing paternity as the bundle of sticks of parentage. So for every state outside of Georgia, a signing of an acknowledgement conveys the bundle of sticks of rights, which you were discussing is like education, not just child support, but custody of things of that nature. At some point, Georgia decided to bifurcate it. I'm not sure why. So under the UPA, the acknowledgement of paternity, it's called parentage now because the UPA accounts for various types of parentage, so like same-sex as well as there are aspects of reproductive. So they use parentage. But it still keeps that marital presumption. So if you're married or if you were married within 300 days of birth, the spouse is presumed to be the father, but again, that creates a rebuttable presumption. The acknowledgement of paternity, in its structure, I want to stress that it didn't come from nowhere. On the one pager, you'll see that I cite 42 USC section 666. That is the federal law that requires the Title 4D and states to have an acknowledgement of paternity. So what the UPA did was that they essentially took that acknowledgement of paternity, made it a parentage, and then added certain protections and other conditions.
Question for you.
Yes.
So if a husband and wife are separated, and they've been separated for a couple years, and the wife goes out and get pregnant by another gentleman, according to our current law, unless I'm confused here, the husband that she's still married to on the books is presumed to be the father of that child.
Yes, legal father.
And a court would have to deem otherwise.
Yes.
You know, it shouldn't be that difficult to get rid of that either. I mean, that's something else I think we need to look at too. If two people have separated, Okay.
Good news is the UPA has a solution for that. So for that case, so that would be the section 607 to 11. So you would have adjudicating a parentage, but let's say you have an acknowledged parent in respect to somebody signed an acknowledgement of paternity. That gives mechanisms for how non-signatories or people outside of that contract can challenge that acknowledgement of paternity. Or for a father, let's say the husband, would be able to then sign under what's called Section 303, a denial of parentage, saying this isn't my kid, and then that can relieve that person of all the responsibilities, and also the rights of that child. So what this does is that this allows for there to be an acknowledgement. Again, states have these, where it's signed by the woman who gives birth and the man who is the father. I will say that the UPA is broader in scope in that it allows for, let's say, like de facto parents. So if you have a couple and maybe father isn't biological father, but he holds the child out as its own, they go out in public, this is my child, this is my dad, and it's kind of like a common law marriage. The UPA does account for that. So I will say as a disclaimer that this is a broader scope and it can be taken in its entirety, or you can leave things behind when adopting. But it allows for this acknowledgement to bundle all of those rights of parentage. So by signing this, if you have mother and father both consenting, they both sign this acknowledgement of paternity or parentages. A lot of states haven't moved away from paternity or to call it parentage, it's still an acknowledgement of paternity. And it's registered within the birth certificate registry office. You now have a legally established parent-child relationship without going to court, without like a judicial determination. There are mechanisms, as stated before, that allows for an adjudication, so a court involvement should there be somebody who contests it or wants to withdraw it or something of that nature. It does build in mechanisms for that. And I know, Representative Hefner, you had comments about, or concerns about the military. This addresses it, because if you have, and I can't tell you the specifics in respect to like how a hospital or a base would communicate, but it's signing an acknowledgement and then having it filed. That is all that would be required to establish a legal father-child relationship, as opposed to needing to do a legitimation proceeding. So it would be signatures that could be notarized or witnessed. Are there any questions that you have?
Is that irrespective of state? So for a military individual who, that occurrence or that birth happens here in Columbus, 3 years later, now that soldier or that family or mother is now in in Florida, is that transferable?
Yes, there's a full faith and credit clause. So something that is legal in this state would be, or the acknowledgement of paternity would be given full faith and credit in another state.
A quick question.
Yes.
How often is a petition for legitimation accompanied by a paternity test, a DNA test?
I am not sure. I can.
Would that be I would just wonder if that would be a routine thing if I were trying to become.
Well, so going back to the signature on the birth certificate, that can be used as proof. The statute does allow for the use of genetic testing as proof of legitimation. I couldn't tell you the specifics on statistically how many times that accompanies it, but it would likely be genetic testing or that signed acknowledgement of paternity that was done at birth. That, again, is creating that legal, I don't want to say parent-child, but that legal establishment of paternity.
I'm not a lawyer, so I'm just wondering if we're looking at a streamlined process, and if without total removal, our goal is not to usurp the judiciary, and as the legislature, there's a reason we have a separation.
If it's uncontested and it's not voluntarily provided, the judge is not going to ask for it if two people are there consenting, saying that I'm the father, and like she said, the birth certificate is presented.
I'm just wondering if that additional information in a streamlined process, in a package of information, here's our acknowledgement, we are both in agreement that this is the file. I'm just wondering in that streamlined process, if that additional piece of information would, I'm not a
Certainly,
lawyer.
no,
I'm not a
I
judge, so
think
I'm
you're
wondering.
right. No, I think you're right. I think that would prevent some of the errors that Representative Smith was talking about earlier, where, you know, an individual went through the process of legitimating a child and it wasn't their child, you know, and so I think it just provides more clarity to the situation earlier off in the child's life, in the formation of that relationship. Especially if we can biologically determine that the child belongs to that father. I think this it does more good, and I don't see any bad at all, but it certainly helps in the situation.
And the UPA allows for admissibility of genetic testing for determinations of parentage as well. So all of these safeguards are built in. So should there need to be an adjudication because there is somebody who is contesting or challenging an acknowledgement of paternity, the Universal Parentage Act gives guidelines on how certain things like genetic testing could be how it's admitted into evidence. It also provides a process for, again, going back to like non-signatory. So if you have somebody who comes in and says, no, that's my biological child, how they would be able to challenge these acknowledgements of paternity. I will say, again, you don't have to adopt it in its entirety. There are certain provisions like a 2-year bar on a challenge of an acknowledgement. And that is to prevent the situation where you have a father who's been there for 2 years, 3 years, and then they separate, and then the father's like, well, that's not my kid. And then they want to rescind their acknowledgement of paternity. The act allows for, or has provisions for when one can be challenged outside of 60 days. So going back to that federal law about paternity, there's a 60-day rescission period. That carries over with this acknowledgement as well. And outside of that 60 days, it can still be challenged legally, like in the court for like fraud, duress, or material mistake of fact. So it's not completely removing the judicial aspect. This is more so for if you have two parents who are consenting to this parent-child relationship or this dynamic or this triad, they are consenting to the creation of it. Should there be a contest, there would still be a legal mechanism. If, let's say, they sign this acknowledgement and the relationship is great, and then 4 years later they separate, the court would still need to intervene if they were trying to create a formalized parenting plan or custody or some type of formalized relationship like that. And that's really where that best interest of the child framework would come in. It's been mentioned many times about this idea of like this burden shifting and how right now legally as it's set up, a mother has to be proven unfit to have care, custody, and control removed from her by the state. And for a father, he essentially has to prove worthiness for it to be granted to the state. But even then, it's more generous because a mother is still a legal mother up until a termination of parental rights. So right now we kind of have this system where for fathers to be granted paternity or parentage and that bundle of sticks, the state has to first find that they availed themselves this opportunity interest, like they did things that they were supposed to do to show that they wanted to have this parent-child relationship. But then Georgia adds this additional factor of, and we have to determine it's in the child's best interest. So as a means to streamline at least those processes or those cases where mother and father are in agreement, they are willingly, freely, voluntarily, intelligently entering into this contract of parentage, the Universal Parentage Act and an acknowledgement of paternity would be able to do that. I am happy to answer any questions if there are any.
I'm hopeful that you'll come to Augusta in September, and I'll get there an hour early, and I'd like you to grill me or quiz me on the Universal Parentage Act to make sure that I completely, thoroughly understand it.
I'm going to do this.
Very good. Thank you so much.
I will be missing that session. I will get that right at 10 o'clock.
Well, we can have fun. It can be fun. Like, what are we talking about?
I'm sure that our vice chairman already knows it can cite chapter and verse of the Universal Parentage
I
Act.
passed 2 bars. I don't want another one.
You did
That is
send
valid.
it, and thank you for sending it a month ago. It's a tome, and so thank you for streamlining that for all of us to get through. Okay, Ms. Buzz, thank you so much, and see you next month, hopefully. We have a few folks in the audience who'd like to speak to the issue. Is Mrs. Michelle Lockhart here? I know apologies to everyone here, we are running a little bit longer than we said we would, so if you don't mind, let's try and keep it nice and compact if possible.
Yes,
Thank
sir.
you.
So good afternoon. Is it afternoon or morning? I think it's afternoon. Okay, so good afternoon. My name is Michelle Lockhart, and I like to introduce myself as a mother, a community advocate, education. I do it all in the community, and I've been doing it for a very long time. I have a background in criminal justice, so I've done a lot of papers on like things that affect the crime rate, things that can affect the budget for the state of Georgia. I did a paper on the budgetary constraints in Georgia, and we looked at how much of the tax revenue was going toward the judicial system, how much was going toward education. And so one of the things I wanted to bring up to this committee that I haven't heard anyone speak about as it relates to legitimation is how this is affecting your crime rates. I haven't heard anyone really speak to that, right? So what I've noticed, and let me just preface this by saying, I am someone who has coordinated hundreds of legitimation clinics in Georgia. I've worked with thousands of dads in the state of Georgia, okay? So I'm the point of contact with every step of the way, and I'm not a lawyer, so I can't help them with every single thing because, like a lot of other people have already said, that takes money and people who have passed the bar. And I tell my dads, if they have not passed the bar, do not take advice from them, okay? But what I would say to that is, a lot of dads that come and file for legitimation, it triggers TPOs, and a lot of them wound up being thrown out because there were no merit for the TPOs. Sometimes you'll have mothers who say, well, now you can't see your child, you can't go up to the school. So now you're removing dad from the educational component. Dad can't even go up to the school. The reason I'm bringing that up is because in the paper I did on budgetary constraints in Georgia, we saw that the courts and education didn't get a lot of money in different cities. So in the cities where this legitimation is hitting us really, really hard, listen, we can start with Fulton County, we can go to the Cab and some of your metro areas, your crime rates are high. You have children that can't read on a 3rd grade level. All of these things are stemming from legitimation and dads not having access to their children. Does that make sense? Okay, so, and I'm gonna keep it short. Last time I said I was gonna keep it short, and I think I did. So I'm gonna disregard this dissertation again, okay? So the other thing I wanted to just say real quick, we've talked about all the problems, so I just wanted to throw out a few suggestions for the committee. I think there are a few voices that are missing here. So while this is an issue that affects a lot of fathers, we also need to hear from the mothers, because the mothers are also being affected by this, because a lot of times when the mothers get along with the fathers, now they're like, wait a minute, what are you doing filing this paperwork? I don't even know what this is. And the mother will go and start being reactive and disrupting what was typically a good relationship between the mother and the father, right? So I think we should at least hear from the mothers, whether they consented to legitimation or they didn't. I think we should bring the mothers in. I think we should hear from grandparents too. She's a great example of why we need to hear from grandparents, because I meet a lot of grandparents just like her who are fired up about this legitimation piece, okay? Another group we should bring in, I think we should bring in, of course we should bring in dads. And I know you speak of veterans a lot, and thank you for your service. I have veteran dads that are made to go through these processes like mental health evaluations and all this stuff just to have access to their children. So it is definitely affecting your veterans. So I think we should hear from those dads, and we should hear from other disabled dads, okay? We should hear from people who may not be able to articulate themselves the way most of us are able to articulate in front of a judge, because that's something that's actually hurting people when they go in front of the, when it's time for legitimation. Real quickly, let me see. I think this is my number 2 solution, the second solution I have written down. Accessibility to all of you on this committee. I wanted to bring y'all 100 dads to come and speak to you all. And so in speaking with the dads, they asked me to ask you all if they could write letters or do something on Zoom so that you all can hear from them. Okay? So I want to know if that's something that we could arrange to do, because they can't afford to take off of work. They're already, we know what phase, we're in a different space right now. People are losing their jobs left and right. So whether we do a Zoom call or however you guys decide to do it, I just wanted to throw that out there. My third solution is outreach. So when the judge spoke about what they're doing in Muscogee, I have dads that from Columbus, I have dads all over. How many counties are there? 157? 159 counties. So I work with dads in all those different counties, but a lot of them aren't even sure where to go to a legal clinic. So I think for each court district, we should know, like, if you all are doing something, it sounds like he's really like one of the only ones doing something. But I'm like, if we have other systems doing things, I think we should put emphasis on outreach and how we helping the dads. With me running the clinics, one of the issues I run into the most is trying to keep up with the process of each district. If I'm doing a legitimation clinic, I break them down by Fulton County, DeKalb County, Gwinnett County. I can only do so much because everybody's running their operations differently, right? So I think it's already been brought up to streamline the operational side of legitimation, so there's like it's like one way of doing it instead of everybody having a different way. Because what's the point of doing a legal clinic if the lawyers and myself, we're not familiar with what you guys are doing on a Tuesday, okay? So somebody brought up the Parker's affidavit. If we tell the dads, oh, you can go get a Parker's affidavit, and you drive an hour away because they don't have the e-file system, okay? You have Peach and Odyssey, but some counties don't have that. And when they get there, they say, oh, we only do Parker's affidavits on a Tuesday. But you're there on a Thursday. You see, if everybody could, I think so, streamlining is one thing. And I think that's all I have to say for now. I'll be in Augusta, and I wanted to see if anybody had any questions.
Do we have any questions, committee members? Thank you.
Next time y'all gonna have some questions. You never had no questions for me.
Thank you. Thank you for your presentation. Also, public comments can be sent into our committee. They can be sent to Brock Perry's attention, and they will be entered into the committee record. So, so there's that. And of course, I know that all of my colleagues are accessible via email too for personal conversations. Great. We have Steve Brown, Fathers Incorporated. Mr. Brown.
Hello, everyone. My name's Steve Brown. I'm father to Messiah Miller Brown, DeKalb County. I went through the fatherhood program, and I'm here just to tell a little bit of my story, and if you have any questions. I was an uncontested legitimation. My child's mother was a part of the process the whole time. We went to court, filed all the paperwork. She was there with me at court every session. She even came to some of the programs that we had at Fatherhood Incorporated, I'm sorry. Yet still, it was still a struggle. They had legal counsel there at one of their meetings that helped me with the process. And yet, when I went to go see the judge, we got denied. And I went back, I saw a legal counsel again when they had a second session, and their legal counsel even was like, I don't understand what the problem is. You know, like they go through this all the time, and they really wasn't understanding why that the judge was denying me. I went a second time, denied again. I waited till my son was 3 years old to even file because I wanted to make sure I had the money and the resources to do everything. But I came across the program, so I just went with the program instead because it was $3,000 to start, to even get a lawyer or anything like that. So thank goodness I had that money, but I went through the process that they had for me instead. The third time I went to the judge, I finally got approved, but I got approved because it was a substitute judge. This judge, thank goodness for this judge, I was talking to the bailiff. I was in contact, I believe what it's called, with the bailiff throughout this whole process to ask her questions and find out what did I need to do differently. Although all I keep on getting back is we can't give legal advice, but she did her best to guide me. So by the third time, she knew who I was, she knew my child's mother, and when we finally went up to speak, the judges, you know, asking us questions and everything, and I'm like, I don't understand why we're getting denied. We're doing everything right. And then the bailiff was like, I remember you. You're, you know, Steve and everything. Like, yes. And the judge was like, can we legitimate them? Can we get this process going? And she was like, yeah, we can do it. So we got sworn in and I got legitimated, but it was irritating because that's all it took.
So when you're denied, the judge doesn't render a decision or give you an appeal approach? Is that it's just denied and there's no follow-up?
It was a denial, and we was told that some paperwork wasn't filled out correctly. And when asked what wasn't filled out correctly, it's back to that terminology, I can't give you legal advice. I wasn't told what paperwork, I wasn't told nothing, just simply something is not filled out correctly. We'll see you again next session. And they would give us a new court date, and that was it. And then the court dates would be almost 3 months in between time. So it took a year from my first court date till I finally got my son legitimized.
That's baffling.
Yeah.
So they couldn't say page 5 of your packet, page 6?
As far as I know, the judge said that would be giving legal advice, so she couldn't give it. If I had a lawyer, then my lawyer would be able to, but again, they had a lawyer that would sit with us and talk to us. I think it's also the county I was in, because I would talk to other fathers, and their process was a lot simpler and everything, so I think different counties do different things. But my
What county were you from?
It was DeKalb County. But I'm pretty sure it was my judge also, because I was the last person to go, and I would see everybody else go before me, and people would be like, not this again, or what. Like, it just seemed like, I'm sorry to say, it seemed like it was the judge.
You know, the part that baffles me about this, Representative Hefner, is that from the beginning, he made it clear that they were consenting. Him and the mother are saying, you are the father and we want you to have these rights.
And it seems
And you're trying to
like
get
it
it
is
done,
such
and it's
a waste of resources.
Mr. Chairman, that shouldn't be possible. How is it possible that a father can be with the mother, and I guess you guys, so you're very confident that you're the father, and maybe some
No, I had a
biological
DNA test, but I had
DNA
to test
test
myself.
done and everything
With a
done.
DNA test.
DNA
But the
test,
courts
everything.
rejected
I did everything
Yeah.
the right way and stuff.
See, it shouldn't be a rejection option, in my opinion. It should be if we have the biological data to show that someone is the father and the mother and the father is consenting, the judge wasn't in the bed with them. The judge is not going to pay child support. The judge is not going to fix a school bus lunch. The judge is not going to go to a parent PTA meeting. Their father shouldn't be denied rights like that. That's just my opinion. And so,
It almost appears as if, to the speaker earlier who talked about the Parents' Bill of Rights, it is an egregious overreach for a judge to be able to challenge that without a warranted, plausible explanation or recourse for the parents, even the mother who has inherited all the rights. She is now prevented and impeded from exercising her wishes at the expense of this judge having the authority to say, I disagree with the presentation.
Thank you for those comments, representatives, and thank you for this really important testimonial. It does demonstrate in our judicial system that there can be inconsistencies, how long it takes for one jurisdiction versus another, inconsistencies in human beings and judges. So thank you. It's a great example for the committee, and thank you for coming today for that.
Thank you for having me.
I just want to echo that, Mr. Chairman, if you give me a moment. Brother to brother, I'm very proud of you that you would stand here and share your story, because a lot of people don't have the bravery to do so. A lot of people feel that those type rooms are beyond my ability to even articulate what I have been challenged with. And you did it exceptionally well. And I'm proud of you.
Very brave.
Very proud of you. Thank you so much
Thank
for
you.
sharing your story.
Thank you.
Okay, Rodney Kellum, am I pronouncing that right, Mr. Kellum? Fathers Incorporated.
All right, I'm kind of high from the mic, but hopefully everybody can hear me. Yes, so I'm Rodney Cullum. I get to serve with my colleagues over here at Fathers Incorporated. And I would like to highlight narrative and my gratitude for this committee in allowing a different narrative to be spoken. I was raised predominantly by a single mother, and the narrative I was raised around was that a perspective of a woman. I'm privileged to be married to the mother of my children. I have 3 children. What I've learned when I got into the fatherhood space was that even as a man, and a lot of things are being shown during these meetings, that we don't have the whole story. Before I started working at Fathers Incorporated, I was given information by some caseworkers that dealt with men. And these were women. These weren't men, these were women telling me a version of a story of the man who has multiple children with multiple women from a perspective that I'd never even thought to think of. From the perspective I was raised with, those men are bad, those men make bad decisions. And when I heard from these case managers of how these men were raised predominantly by women, no fathers in their life, and when they become of age and start having children without any training, without any way to understand how a man is to operate, without an education to get the proper income to take care of children, they go from situation to situation uneducated, unfunded, and unloved. And when I learned from Michelle Lockhart, when I learned from our case managers, when I learned from our dads, when they call in and I speak to them, and we heard a version of an uncontested legitimation case, the heartbreaking stories that I hear from dads, that when they finally call Fathers Incorporated, they are exhausted, they're tired, they're beat down, and they often feel like they're unheard. They feel like, what else can I do? This is a last-ditch effort for somebody to even hear me. And on a regular basis, they say, thank you for listening. Because it's the first time when they call us that someone actually listened to just their situation. Someone actually listened to how they feel. And it's very difficult for men in general to share how they feel. There's not many safe spaces. There's not really a safe space when you go to the hospital and you're the father that you feel welcomed. It's not very common that you walk into a school trying to engage with your children's education that you feel welcome as a father. In your children's life and in general, there's not many spaces outside of sports that men are made to feel welcome. Hey, Dad, welcome. And I'm grateful that I get to be a part of Fathers Incorporated because we do things like the Million Fathers March, which helps dads engage in their children's education, that the schools welcome them. So lending my voice is just to lend a highlight that I appreciate that through these committees, these meetings, that we get to hear a different narrative. We get to hear a different story. I like how you highlighted that dads are being used as banks. And unless you do it perfectly, unless you choose the right partner, get the right education and income, marry that person, and get all these steps right, will you have a chance of being celebrated and appreciated. If you do any of those steps wrong, you can be villainized. So I appreciate being able to highlight this narrative, and I'm thankful that these meetings and what we're hoping to do can help change the narrative. And that's, even changing the narrative opens the doors for people that, when you go to present legislation, will be able to hear you, because we're changing the narrative, and that's what I'll say.
Thank you, sir. Thank you for the great comments. And last, Kenneth Braswell. Welcome back, sir. Thank you for making the trip.
Thank you again for allowing us to come and share our thoughts. I'm so proud of my staff. They are in the midst of this work every single day. This conversation that we're having here and that we had in Atlanta and that we will have in Augusta is just a resignation of what we are experiencing as an organization. Working with fathers in the state of Georgia, more specifically in Metro Atlanta, and we are proud to say that we have already begun the recruitment effort and have dads that will be in our next cohort right here in Columbus. And so in another few months, another few weeks, those dads that have signed up will be in our cohort, and we will begin to do the work here in Columbus. A lot has been said already, and so, but there are a couple of points that I just wanted to kind of settle in on, because I think that it simplifies the conversation and gives us some other viewpoints to think about. One of those areas is the established. In my mind's eye and how I see the birth certificate and everything on the birth certificate is all about the child. It is the record of birth. What is happening at the time and what are the statistics or the vital statistics with respect to when this child was born. Date, place, doctor, all of those kinds of things. The mother and child, and I'm only thinking about my own birth certificate and the birth certificate of my children. On my birth certificate, my mom and my dad's name were on the birth certificate. They were not married, but they were on the birth certificate. What I assume is that at that point, that his name specifically was who was recognizing me as a child as my dad at that time. So if I didn't get a chance to see my birth certificate until 10 years later, I can look at that birth certificate and say, this thing tells me who my mom is, and it tells me who recognized themselves as my dad at the time. Doesn't necessarily mean that he's my dad, because paternity wasn't established. And we have a lot of conversation about, well, mothers don't have to establish paternity, because the birth certificate is typically made out at the hospital. There is physiological, biological proof at that space that the child was birthed by that mom. There's no need for paternity for her. If that is the litmus test for paternity of a child, why isn't the same litmus test used for the father? So if you're going to use DNA in the hospital at that point for her, do the same procedure for him to recognize at that point if he's there. Now, we know that sometimes, most of the time, he's not there, but we do know statistics say right now that 85% of parents who are non-married are at the birth of their child. They are more likely there than not there. But if they're there, take their DNA at that point. If it matches up, then you have the dad sign the birth certificate at that point, and now it establishes paternity. But when you look at the birth certificate today, that doesn't necessarily establish paternity. It only establishes who at the point, at the date of birth, recognize themselves as my father. So that's one thing. The second thing is, that would help with legitimation, at least in those cases. The second thing is when we start talking about legitimation and where it was established, Today, we're having the conversation in context of family. But the original laws weren't created in context of family. They were created in context of business and inheritance. They were built because wealthy people did not want unlegitimized children to have access to their wealth. It was about business. It wasn't about family. And so the origin of the law and the principle to which we're having a conversation about it today is totally different. So we can't expect that a law that was built on the premise of business and on business and inheritance took into consideration family context. It did not take into consideration family context. So now we're here and we're talking about why a law doesn't respect the nature of family. It's because it wasn't intended to do that in the beginning. So as we continue to kind of look at legitimation, we have to take it in context of something that was built that wasn't meant to be and what it is we're trying to get at today. And so if we strip apart trying to fix it and make it amenable to where we are today, and think about it more in the sense of what is right and what is wrong. What is right and what is wrong is that children deserve access and rights to their parents. What establishes undeniable rights to their children? DNA. So at the earliest point, we can get DNA of their children before life happens, right? Because this is what happens when life happens. The research and statistics says that there is no noticeable difference in interaction between a non-married couple and a married couple within 1 year of the birth of the child. They are still in a romantic state. It's a point of opportunity because everybody is still happy about the baby. No one has any issues. By year 3, the non-married couple or the non-married dad is less likely to have engagement with the life of his child. What that means is that between year 1 and year 3, life is happening. He's not working. They're not getting along. They're not married. They don't live with each other. All kinds of things are beginning to happen. So by the time they look at legitimation and you're looking at contested and non-contested, the argument for non-contested is not based on paternity if you establish paternity up front. The argument for non-contested has nothing to do with paternity. It has to do with proving that the father has the ability to be a good father based on our criteria. So if we stop and separate this paternity piece from this proving he's a father piece, we can begin to start thinking about the contested and non-contested cases, because the reason that the contested cases are so difficult is because the argument isn't about paternity. The argument is about whether one or the other believes that this individual is fit to be a father, which is why when they get to court, all other things become an issue in the court except paternity. Do you live in a household where you can actually have visitation with your child? Are you working? Do you have a DV case against you? Do you have all of these things that then frame whether or not he is suitable to be a father that has absolutely nothing to do with paternity? So I think if we take those 3 things and start stripping them apart a little bit, these other pieces will start to make sense, because we'll stop having a conversation about apples when we're talking about oranges. Does that make it? I know that was a lot in my head. I tried to articulate it, at least how it was in my head. Did I make sense? Yeah. Okay. I never know sometimes. If somebody had to tell me I'm making sense. But that was it. I just kind of wanted to kind of lay that out in the hopes that that would kind of give you all some sense about thinking about everything that you're hearing, because when I pile up on what I heard today and then what I heard in Atlanta, this is a lot. And I can only imagine that Augusta is going to pile some other things on top of it. And you guys are going to have to go away and try to figure out, based on everything that you heard and everybody that you heard from, what makes the most sense to move Georgia forward. And to the extent that I can kind of make some sense out of it based on what we've done, what I've heard, and what we're experiencing and the dads that we're working with, that is why we want to be here. We want to make sure that we can help you in that space and really being able to take the information that you're getting from us and be able to do great work with it in the state of Georgia.
Thank you, Mr. Braswell, and your comments made perfect sense, especially on the paternity, and honestly, were insightful and not necessarily what I was expecting. So thank you for that. We do have one final person to speak. Arisha Lawrence, are you here? And did I pronounce your first name? Did I get close? Thank you.
Greetings, everyone, and welcome to Columbus, Georgia, Mr. Chairman, Co-Chairman, Mr. Teddy Reese, esteemed committee members, and executive assistant. I see your work. My name is Arisha Z. Lawrence, and I am here on behalf of a close family member. I'm a proud constituent of North Columbus, so hi, Representative. We sat together at a recent, early in the year, creative economy something at the State House, but you came in late. I was right there, and I was probably half asleep, but I was paying attention. Normally, I'm advocating for music rights globally here around the state. Just came back from Costa Rica. However, I am here because I'm speaking on behalf of someone close to me, and it happens to be a family member. Because I am in the music industry and I serve at a very high level in that regard, what I do see all the time is many music studios, film studios, filled with men that are crying in mics, instruments, and through a beat. And recently I witnessed it personally myself, literally 2 months in. So we're going through the legitimization process. This is a learning thing for me, never heard of it, but I'm learning so much in these last 2 months. It's kind of like changed my perspective on like, whoa, this is what dads are dealing with? I would have never had a clue. I thought everybody was happy. The problem I see is education affordability and the time frame of legitimization when mental health and illness of the mother places the children at risk. Mental health plays a vital role in regard to a lot of these family discrepancies. In this particular case, there was a father and mother dating, living in Texas for 10 years. They wanted to move to Georgia, to where the remainder of their family really was, and he wanted to be closer to his siblings. So he moved the mother and the 2 children. They're unmarried, but he signed both birth certificates, and they had been living together for over 10 years. A 4 and a 6-year-old, one autistic. They moved to Columbus, Georgia, 10 months in. Suddenly, one day, the mother disappears. She has had a history of mental health. She steals the car. She disappears. She takes the 2 children. We finally found her because Columbus is a small community, and she was in a hotel with the children in a tub. We couldn't enter. So at that point, as a family, we just decided we're going to sleep in these cars, and we're going to watch that door. Because I get the law and we get everything, but what I will never get, and what none of us and what we agreed to, is we're not going to suffer if something happens to those children on our watch. So we stayed there all night, taking small naps here and there, watching that door, for that door to open. Finally, that door opened the next morning, thank you, God. When it did, the mother came out. She left for a very long, reasonable time. The children didn't come out. Our hearts are pounding. We're like, what is happening? What's going on? Are they okay? I'm crying. I'm definitely not that, but I got very emotional. Seeing that and witnessing that, maybe 40 minutes later, after we've called the police department, thank you for our officer, Katina, and her team, the door opened. The mother still hadn't come back. We're at a hotel, and it's not a good hotel. Probably 0 ratings. But one of the autistic son came out first, 6 years old, opened the door, and he ran right into the street. My heart dropped. I jumped out my car, and everybody's like, no, stop. We don't have custody of those children. Don't do that. Because all of these rules and laws against this dad who's been working hard and was raised by two great military parents overseas. He knows how to keep a good family. He just never married her, right? So there's the issue. So we didn't intervene, but we're watching. The police are called. Then the daughter comes running out. Moments later, I guess the mother was alerted. So she was, I guess, eating breakfast in the hotel herself without bringing food to the children. The police were called, and then she was running towards them. They're in the street. The police are there. They ascertained her because mental health was the state of mind of her condition, of her state. The room was dirty. It was a lot going on. All of that to say, I'm here today to speak on what do we do in the cases where they're together and then instantly something happens. She's admitted to the Bradley. She's there because it's a holiday weekend, Juneteenth. They couldn't really do anything legally. The courts are down on a federal holiday, so we had to wait until the next Monday for something to be done. She was released when that something was to be done. This process of legitimization that Judge McBride spoke well of earlier, it works, but in this case, it's not working because the time frame. Remember, mental health. Mom is suicidal. Mom may want to do something to herself or the kids. There's a lot at stake. She was released because she knows how to trick the system, and according to, varied doctors who have talked to, she's good, right? She knows how to answer the question when and why, but when she has these episodes, if they're not very consistent, then, hey, we can't put her in a white coat. That's my terminology, because I'm no NP. With that stated, my only question is, or maybe it's just a consideration, consider the mental health, consider emergencies, consider there are good fathers out there that want their children, but if something like that happens, what next? What do you do? So that's my only comment, and thank you for your time. Thank you, Representative Reese, Representative Vance, and welcome again, y'all, to Columbus.
Thank you for those great comments, and we appreciate your being here today. I think that concludes the comment section and the presentations. Gentlemen and lady on the committee, any final thoughts, comments? We're just so grateful for everyone being here today. I take a little personal prerogative as chairman and say, we all turn on the news, we all read the paper, and we all hear about politicians and politics. And I can absolutely tell you how proud I am to serve with these committee members. This is a true bipartisan committee. These are people that genuinely care about what's going on in our state and how to make our state better. And they sacrifice a lot to do this, and they're just the finest people I know. And it's so funny, so many people in elected office just get a bum rap sometime, but I give you the counterpoint of these people who I know well personally, and they are absolutely committed to the folks in Georgia and to the work they do. So thank y'all for that. I appreciate y'all more than you know.
Mr. Chairman, if you will, as the vice chairman of this committee, I just want to thank you for your leadership, for getting us to this point. I'm just so filled with the testimony and the knowledge that we are gaining from everyday citizens of Georgia. This is what you want the legislative process to look like. You want to hear from people. You want to hear the challenges. You want folks' input in the process. And at the end, hopefully, we can find ourselves in a space where the people of Georgia are happy. And so I'm very happy thus far with your leadership and your guidance with us on this committee. And on behalf of the citizens of Muscogee County, Columbus, Georgia, it was truly our honor to host this committee here. Vance, Representative Smith, you allowed me to say that on your behalf as well. It was truly our honor to host a committee meeting here in Columbus, Georgia, so that we are making sure that we are intentional about when we say we're making laws for Georgia, we're not just confining ourselves to Metro Atlanta, but we are venturing out to hear from some of the deepest and darkest corners of this state, those folks that oftentimes feel that their voices are not heard and that we somehow have forgotten about their plights and what they experience. And those of you who drove down to visit us, thank you again for coming to our city. And I would like to just shamelessly plug that Columbus is the second largest city in Georgia. And we are honored to do so. We have a world-renowned whitewater rafting course, which will host the World Cup of Whitewater Rafting in 2008 and 2009. We beat out Paris, France for that competition. And so we're very excited about that, of what Columbus is bringing to this state. And we also have a new AA baseball team, the Columbus Clingstones, now the Atlanta Braves, for the first time in a long history of the organization, have all of their 3 affiliate teams in the state of Georgia. Single A is in Gwinnett, double A is here in Columbus, and I think triple A is in Rome, if I'm not mistaken. But all of the Braves affiliates are now right here in the state of Georgia, and we are so honored to play host. And again, on behalf of the residents here, it is always our honor to do our part in making sure that we are advancing the causes and the concerns and the ideas of the people of the state of Georgia. So thank you, Mr. Chairman.
Thank you. On that note, our meeting is adjourned.